devise a video conferencing solution made entirely for courts. And it should be indigenously made. Now the question is, who controls this software or this technology? Once the software and technology has been made, it must remain in the control of the judiciary. I am a great votary for that, because that is how the judicial system has evolved. All judicial records are in the custody of the judiciary.
The experience that I've had with Zoom tells me 2 or 3 things. If you're going to use this even in some sort of a hybrid model, one of the things you need, which Zoom does have, is the feature called a breakout room, where 2 judges or 3 judges on a bench can confer privately without the rest hearing. That's the first. Second, you must be able to send a file transfer, just as you would hand up a document to a bench in court. You must be able to hand up a digital document here. There must be master control, so you can mute everybody and unmute, and that must be with the court master or the court master and the judge. And that tells us that we must have a system of delegating administrative control. All of this tells me that what we need is not an adaptation of any of these useful platforms, but a specific technology evolved for our systems, as Badar has in fact been saying. But these are the 2 or 3 key design parameters that must be told to them. Now, what NIC seems to do is that they decide what we want and then tell us to manage. Now, apparently, video does have a feature of breakout rooms, but it's centrally disabled because nobody figured that we would need it. So they've just knocked it off. We can't, and we have what are called tenant nodes or slave nodes, so we can't start it. They've just disabled it at the enterprise level. The breakout rooms are also often important because you can assign breakout rooms to arguing counsel and the arguing counsel team, so they can confer. It's a bit delayed, but certainly that can be done. These are design parameters that we really need to build in.
So when we look at this thinking in general, the systems thinking, it is fundamentally about how do you shift the equilibrium of a system. And kind of as I hear the conversations going on, I think one very important point is many times we look at solving for one part of the system and not looking at the system as a whole. So how do we kind of make those incremental shifts which are permanent and which you kind of call as a +1 thinking, and ensure that while you might solve certain parts of the system, but ensure that the overall system as a whole is thought through, so that what you build kind of creates a system of virtuousness versus viciousness. And fundamentally, it's about how do you zoom out and look at the system from a point of high leverage, which is the changes I make in the system, while it adds value, ensure that it does not disintermediate or cause too many negative frictions for the system as a whole, right? And this thinking of systems kind of really lands on platforms. And Deepika, happy to spend a few minutes if you would like on platforms.
Please do, Anand. Please
okay.
do.
So platforms, the fundamental construct of platforms is to ensure that you foster interactions of the various actors, right? You don't really look at pushing something which is centralized. Again, going to a lot of points Justice Lokur and others had spoken about, is don't try and push what you think is right, but ensure that the local context is completely considered. And only when you bring that local context into the platform do you start seeing adoption of solutions, you start seeing interactions. And a platform in some sense is fundamentally about being sensitive to the needs of the larger ecosystem, being able to constantly evolve, constantly learn. And the reason this is important is because the problem is never static. The problem is always dynamic. And how do you ensure that what you do through the ability of your infrastructure or standards or solutions continues to evolve at a scale faster than at which the problem evolves, right? And 2 important constructs of platforms are really the aspect of a digital infrastructure, which can play the layer of unification, and also the aspect of data. I think we had people talk about data. And data, in some sense, is not just the oil; it becomes the soil of the system, right? On which the system kind of starts evolving and building and maturing over time.
But one interesting feedback that I got was from the district lawyers in Kolhapur who came to the open meeting. And they said, this is wonderful. We don't need a bench or even a circuit bench in Kolhapur. We don't need to travel to Mumbai and wait, case may or may not reach. Our clients save money. If you can do a hybrid where one of us can join from Kolhapur, you can set a time slot, we'll argue our matters sitting in Kolhapur. Enormous saving to client, enormous saving to lawyers. They're very keen on doing this at that level. This I found out from judicial officers is also their feedback, that if you institutionalize it, judicial officers should be able to do this, technical constraints aside, with lawyers who are in far-flung districts. Justice Qureshi says, I spoke with him, that in Tripura, it's enormously advantageous because the lawyers have to travel 6 and 7 hours by road to get to Agartala and go back very often and come back 4 or 5 times because their cases haven't reached. He says, this way I can schedule it. He doesn't have to leave home. We keep to a time plus minus so much, and we'll actually get more disposal, especially in criminal matters and in criminal appeals. That was Justice Qureshi's feedback from Tripura.
I think Mukul has raised a very important point. You know, what is in the mind of the judiciary at the moment? You know, it's not at all clear. It appears that what they have in mind at the moment is, all right, let's hear some cases. And how long this lockdown will last, nobody knows. And when it is lifted, then we'll see what is to be done. So I think really it's for the judiciary to answer that question. And there is no clarity, unfortunately, on this. But the way, you know, I would look at it is that, you know, video conferencing would have to be a supplement. It cannot be a substitute for, you know, in-person hearing, whether it's through lawyers or whether it's through parties. It's just not possible. You can have a situation, for example, you know, now they say that the airfares are going to go up 3 times. Now some litigant in Bombay wants to engage a lawyer to come and argue in the Supreme Court. Right? So instead of having to spend the airfare and hotel and so on and so forth, perhaps he can argue it from Bombay. That's one aspect. The other aspect on e-filing. Now, all the lawyers are supposed to be, I mean, not all the lawyers, but all the advocates on record are concentrated in Delhi. Why is it not possible for a person from, say, Chennai or from Mumbai or from Calcutta or wherever to file an SLP? You know, you have advocates on record who are practicing there as lawyers, but not as advocates on record. That can also be done, cost saving, time saving, everything saving. So I think the judiciary has to make up its mind and tell us, or tell everybody, you know, what are they looking at, right? And then you can have, you know, look at various options.
We must have some level of standardization and commonality between processes, rules, and forms. It just can't be that Calcutta, Tripura, Mumbai, Ahmedabad, Delhi, Supreme Court all do different things in different ways.
Correct.
If you're going to unify this, then that's the first step we must do. Otherwise, it's just garbage in, garbage out.
So to me, it appears there's a great need for standardization. Right? So you cannot have different systems across various courts over various states and so on and so forth. So the standardization would also require sizing, you know, sizing of the network, looking at the volume of the video volume and on the audio volume, also the amount of file sharing that will be required to support, you know, 20,000 odd courts all over at different levels of priority. So I don't see there is any difficulty with provisioning. There is obviously a difficulty with prioritization. So there has to be certain policy implications of this. But the country can definitely, in my opinion, support the network. But the sizing will have to be done extremely carefully. Then, the sizing does not only involve the network, it will also
Sorry,
involve...
Subhashish, if I could just interrupt you, because I think for all of us, as in, if you could just explain that a little bit, that what the sizing means, because I'm sure that I speak for many on this, that we are not sure of the technical term.
A sizing would typically mean that if you set up the various point-to-point networks, where the network will have to be dedicated networks, or you can ride over a public network. If you ride over a public network, or even in a dedicated network, what is the exact capacity of the network that will be required, right? So, in terms of bandwidth, what is the exact bandwidth that you need to provision so that you don't get breakages in video and so on and so forth, right? So it's not only the video and the audio, but there are the interactions, there's file sharing, the entire need. And similarly, one will also have to work out the storage and the computing. Where will be the storage servers located? What will be the access, the uploading, and so on and so forth. So there will be some engineering, serious engineering that will have to put in place to do the assessment, the capacity assessment correctly. Right? This is probably the first step.
So that's, having said that, we will need to overhaul a law a lot. The cyber law of India, for example, right now, the IT Act is not, I would not say it is substantive enough. It's more like a skeleton legislation, which needs to infuse a lot of issues which are growing today. For example, we don't have something on fake news today in the IT Act. There are a number of issues. There could be surveillance issues. There could be data leakages issues, and a lot of issues pertaining to deep fakes, for example. We have so many new emerging cyber crimes every day which may not find a clear explicit mention in the act. So we need to do that. Along with that, the practice manuals of the high courts, the Supreme Court, the lower courts will have to be also worked out in a unified code, a standard code, one code which can work across the country. And that, something like that, we have already seen in the CCTNS, the way the harmonization has occurred, or the way the e-court system has also to some degree brought about a unification. On a similar note, the evidence recordal, the electronic evidence, how should we file the electronic evidence? How should we, preserve the electronic evidence, and for how long? All these questions are still looming. So we really need to work on these practice codes and bring relevant amendments in the current legislations, which are there today.
People have been assisting the e-committee in different ways, So really, I think, and my experience with the e-committee for about 5 or 6 years, whatever period that I was there, has been good. We are getting good feedbacks from the district courts, we're getting good feedbacks from the high courts, and the system was working well. I don't see any reason to, change the existing system. A small change has been suggested by the Supreme Court, but the cabinet has not approved it. Right? So that's the other thing, that if you're looking at a change, it has to go to the cabinet, and what the cabinet does, one can't say. But the existing system is good. It can be improved, by inviting more people to come and address specific issues. I don't think that's a problem at all.
I would start by saying that at the moment, I don't think we need a law. We could do with the Supreme Court can lead the way, even though it may not have supervisory jurisdiction. It can lead the way in at least first telling us what the long-term policy is. Is this short-term? Is this long-term? And is it hybrid? Can it be that every day or every alternate day, 1 hour from 3 to 4 is kept for those kind of cases?
There are 2 or 3 areas that I think, we need to understand before we, answer some of these questions that you have raised about the implementation framework and so on. One is that we are talking about something like 19,000 courts, right? And there are a lot of private players, obviously, who are interested in computerizing all these courts. Now, one of the offers that had been received long time back was from Microsoft. And if you look at getting licenses from them, I mean, I'm just assuming for the sake of calculation that each license is 10,000 rupees. I know it's much more, but assuming it's 10,000 rupees. If you're looking at 19,000 courts and jails, legal aid, and so on and so forth, it probably comes to about 20,000 or so. So 20,000 into 10,000, I don't know how much that is, but it's a hell of a huge amount. So, getting a private player, and there were offers also, by the way, coming from other Indian entities who wanted to participate. So that's why, free open source software was taken into consideration, because then we could manage, the E-committee could manage the courts without too much of an expense. And one of the spin-offs of that, by the way, is that the saving in terms of cost has been much more than the expenditure incurred by the government of India. The government of India had given 1,600 crores plus 700 for digitization. That's a separate thing altogether. But 1,600 crores, and the saving is much more. So that's the cost aspect. The second thing is, the privacy concerns. Who is going to be in charge? Now, if you have private players getting into it, they'll have all the data that they want. You have a very large number of cases where you do not want to reveal data. For example, you will have cases of, matrimonial disputes, right? So husband and wife don't want to be identified. You will have cases of sexual offenses, child sexual abuse, some cases under the Official Secrets Act, intelligence agencies, and so on. But private players will get hold of all this information, and they can play around with it.
What it ought to do is that it should take in all intelligent people within its fold, must have people who have, out of the box thinking and come out with good solutions. And why should it shut them out? It should take their ideas and build new systems. There's no doubt about that. Now, insofar as creating a separate institution for this, I'm not for it. It should be within the control of the judiciary, but the judiciary must open its mind, and it must broad base its thinking, and bring in experts into the field. Let the experts prepare the technology, and the judiciary will only guide them what they want. The judiciary, I'm including the advocates also, the judges and lawyers, they must guide the technologists as to what they want from the system. And there is the current state of technology in the world today is whatever the judiciary requires for a court hearing can be produced through technology.